Plenum Fokusstrategie, Dienstag, 18. Januar 2022. United Nations. Summary of the separate and dissenting opinions of President Kasese and Judge Stephen and the dissenting opinion of Judge Lee. President Kasese attaches a separate opinion in which he dissents from the views of the majority of the appeals chamber on two questions. Point 1, the extent to which the International Tribunal may rely on a national law for the elucidation of the notion of guilty plea, and the question whether duress can be urged and admitted as a defense in case of war crimes and crimes against humanity whose underlying offense involves the killing of innocent persons. Concerning the first question, President Kasese considers that one need not rely on the national legislation and case law of common law countries to construe the notion of a not guilty plea. According to President Kasese, that notion should, under international law, be construed in light of the object, purpose and setting of the International Tribunal. This question, he argues, is of overriding importance because it concerns the extent to which an international criminal court may or should draw upon national law concepts and transpose those concepts into international criminal proceedings. The result, however, President Kasese agrees with the majority that the conditions to be met are that a guilty plea be voluntary, informed, non-equivocal, and have a factual basis. The second point on which President Kasese dissents from the majority and on which point he is joined by Judge Stephen, who also attaches a dissenting opinion, is on the question of whether duress, namely acting under a threat to life or limb, might constitute a complete defense to a charge of unlawful killing. The majority holds that duress can never be a defense to such a charge. In his dissenting opinion, President Kasese reaches the opposite conclusion. He contends, on the basis of a survey of copious international case law, that contrary to the submissions of the prosecutor, no special rule excluding duress in case of murder has evolved in international criminal law. He contends, on the basis of a survey of copious no special rule excluding duress in case of murder has evolved in international. So no special rule excluding duress in case of murder has evolved in international criminal law. Judge Kasese maintains that the only logical conclusion to be drawn from the absence of such special rule is that the general rule on duress must apply. Consequently, duress may also be admitted, subject to various stringent requirements for crimes involving the killing of innocent persons. In his opinion, Judge Kasese emphasizes that the appellant, when he pleaded guilty, urged at the same time duress. In brackets, he contended that he took part in the execution of civilians because of the threat that otherwise he himself would be killed. Close brackets. This guilty plea was therefore equivocal in the opinion of Judge Kasese. The appellant, in the same breath, pleaded guilty and invoked a defense excluding guilt. Consequently, the matter should be remitted to the trial chamber for entry of a plea of not guilty and trial, to see whether the conditions for duress are met. Judge Stephen, while agreeing with the majority of the appeals chamber that the appellant's plea was voluntary but was not informed, disagrees with the majority on the issue of the plea's ambiguity, holding that it was ambiguous because the appellant, while pleading, raised what might amount to a defense of duress. Thus, he agrees with President Case that duress is available as a defense to all offenses, including unlawful killing. Under international law, when the strict conditions enumerated by President Case are met, he also agrees with President Case regarding the consequences of this finding, namely that the appellant's plea was equivocal, that accordingly a plea of not guilty should have been entered and the matter remitted for trial. Judge Stephen reaches this conclusion by the following reasoning. In summary, not being wholly convinced that as a matter of customary international law, duress is accepted as a defense to unlawful killing, he turns to the general principles of law recognized by nations. Here it is apparent that while most legal systems recognize duress as a defense, with no exception for murder, common law systems generally make an exception for murder. At the heart of that exception, however, is the notion to be found in the Old English authorities of the evil involved in balancing one life against another. Better, they say, for an accused to die himself than kill an innocent. The situation where an accused would not be able to save the victims, no matter what he did, was not, however, addressed by these authorities. This was the situation, however, in which the appellant, in this case, on his account, found himself. Whatever he chose, the lives of the innocent would be lost, and he had no power to avert that consequence. Hence, since the common law authorities, but for which one could say that the general principles of law favored duress as a defense to all crimes, did not address the issue at stake, and since their underlying rationale did not justify excluding duress as a defense to unlawful killing in circumstances such as those facing the appellant, the general principles of law would allow duress to be raised as a defense even to a charge of unlawful killing. Judge Lee's dissenting opinion deals with two issues. One, whether duress or obedience to superior orders under threats of death can be a complete defense to a charge of murdering innocent civilians. And two, whether this case should be remitted to a trial chamber one for trial. With regard to the first issue, Judge Lee concurs with the majority decision in denying duress as a complete defense in the cases involving murder of innocent civilians, while accepting that duress can only be a mitigating circumstance in the consideration of the sentence. In respect of the second issue, Judge Lee dissents from the majority, suggesting that the appeals chamber should re-evaluate the case of the accused and reach a decision on whether the trial chamber sentence is fair and just. The reason is that the guilty plea is not ambiguous in relation to the plea of duress, and that the plea remains valid because the charge of war crimes is no less serious than that of crimes against humanity. So that is the press release Erdemović case. The appeals chamber rules that Drazen Erdemović should enter a new plea. From The Hague, the 7th of October 1997.